ask that this court overturn the trial court decision granting summary judgment to defendants because the state has shown that there are material factual disputes in the record that the defendants' mailers have a tendency or likelihood to mislead consumers. Thus, the state has shown that there are material factual disputes that the mailers are deceptive under the Tennessee Consumer Protection Act and the Government Imposter and Deceptive Advertisements Act. This case arises from defendants sending mass mailing into the state of Tennessee between 2013 and 2020. The mass mailing that defendants sent into Tennessee targets small business owners or business owners. When consumers receive these mailers, they're receiving it around the time that they're required to file a renewal with the Secretary of State office. The mailers are also supposed to be advertisements, but they don't look like advertisements. They look like official government forms.
What about the disclosure in the mailers?
Your Honor, the fact that a mailer or representation contains truthful information does not mean that the representation is not misleading. In FTC versus National Urological Group, the court holds that court should be looking at the advertisement's overall net impression rather than the literal truth or falsity of the words in the advertisement. Again, in FTC versus cyberspace.com, the court explains that a solicitation may be likely to mislead by virtue of the net impression it creates, even though solicitation also contains truthful disclosures. The state's burden was only to show that there were material factual disputes in the record, that the mailers had a tendency to mislead. And the state has shown that because consumers have explained that when they received these mailers, they were confused and misled about the status of the defendant sending them. Instead, consumers explain that because of the pre-filled business information in the square, the prominent please respond by date, and that pre-filled business information include the business formation date, it included the address and the Secretary of State control number. The citations to the code underneath that, with a one-sentence explanation of the service that they're supposed to be providing or the product that they're supposed to be providing, made response seem mandatory, made consumers think that they had to respond in order to be compliant with the annual records report requirement, or with respect to LLPS, the corporate consent records that they were offering consumers.
Your response begs me to ask this question, whether it's relevant or not. Did the state take out a survey, make a survey, as to the number of consumers that actually made complaints and the nature of those complaints?
The state did not conduct a survey about the number of consumers, and the state, I would submit, and the state would submit, was actually not required to provide that information in order to show that there are material factual disputes, because the state had direct evidence from consumers. If you look at FTC versus cyberspace, that court found that the consumer declarations alone were sufficient to show a likelihood to mislead.
You're telling me about consumer declaration, but you're not telling me what is the basis of these declarations that you received, that you present any proof in the trial court by affidavit as to the amount, the number of consumers, the percentage of the consumers that received these that actually felt that they was misled.
What the state presented was representative of the consumers who were misled. The state was not required to provide evidence of the percentage of consumers who were misled by the disclaimer, because the standard for the state was to show that there are material factual disputes in the record, and deception is typically a question of fact to be ruled on by a jury. The state is not required to find every consumer who received defendants' mailers and ask them that whether or not they found it misleading. And in fact, there's nothing in the record to suggest defendants' position that a small percentage of consumers are misled, because defendants are relying on the faulty assumption that if the state did not find a consumer or consumers and ask them whether or not they were misled by the mailer, then the consumers must not have been misled. Further, the trial court doesn't even re-adopt the findings that a small percentage of consumers were misled from its preliminary temporary findings. And it's not clear whether or not the trial court relied at all on its temporary preliminary findings, but to the extent that the trial court did, that would have been an error. In Service Holding Corp. Versus Hall, the court holds that a trial court's disposition of the substantive issues joined on a motion for extraordinary relief is not dispositive of those substantive issues on the merits. Further, in Memento Pharmaceuticals Incorporated versus Teva Farms, the court finds that findings of fact and conclusions, in fact-intensive conclusions of law made by a court in a preliminary injunction context are not binding. It's not clear why the trial court didn't really address these findings again in its final decision in January, but the state submits that there would be no evidence to actually support that position. Instead, the reasonable inference should have been resolved in the state's favor, and the inference from the consumer's descriptions of why they were misled by this mailer, why they thought that the status of the entity was different, and that they were receiving something from a government or from a company affiliated with a government, is sufficient to show that the mailers have a tendency to mislead. And in fact, consumers did take time to describe these disclaimers in the mailer. One consumer mentions that she didn't notice the language about workplace compliance services, that would be ANS defendants, being a private entity until after she spoke to the Secretary of State's office. At that point, the Secretary of State's office confirmed the mailer was not from their office. She already has that in mind when she goes back and she looks at the mailer again. It's upon that closer look that she notices that language that workplace compliance services is a private entity. She recognized that not everyone will notice the small print on the mailer and will unknowingly end up needlessly paying extra money to this company to complete the form.
Did you put forth evidence that there were numerous consumer complaints on this very point?
What the state presented was declarations from Division of Consumer Affairs, Tennessee Secretary of State's office, and the Better Business Bureau about the number of complaints that have happened, that consumers have brought against this company. And then the declarations actually illuminate what was misleading about these mailers. Another consumer described the disclaimer, actually another two consumers described the disclaimers as buried. Those were consumers that received an ANS mailer and the other one received an LLPS mailer. Another consumer stated that she paid LLPS before she even noticed the disclaimer, and it wasn't her that recognized the disclaimer, it was her husband. And she noticed it weeks after she had already paid LLPS. Another consumer also stated that he actually thought that the ANS mailer didn't have sufficient disclosures because he mentions that he has to go back, check his books, and see that the fee looks like it increased to recognize that there was something wrong. It was only after further investigation that he found the mailer said that the company was not a government entity. The majority of consumers had to take additional steps in order to avoid being misled by these mailers. The consumers contact the Secretary of State's office because they are confused and misled by these mailers. The consumers talk to a coworker. Consumers look up the company online. These are the types of steps that the consumers are stating that they make in order to avoid being misled by the mailers. And consumers don't have an obligation to make a reasonable inquiry to avoid being misled by defendants' mailers. The law has actually explained when a consumer is acting reasonably under the circumstances and when a consumer is not acting reasonably under the circumstances. In FTC versus Sterling Drugs, the court gives a apt description of most consumers. It says the general public has been defined as that vast multitude, which includes the ignorant and unthinking and the credulous, in making purchases do not stop to analyze, but are often or too often governed by appearances and general impressions. He is not an expert in grammatical construction or an educated analytical reader, and therefore he does not normally subject every word in an advertisement to careful scrutiny. Then in Resort Car Rental Systems Incorporated versus FTC, the court finds that the public is not under any duty to make reasonable inquiry into the truth of an advertisement. And in fact, an advertisement that is secured by deception and showing that is sufficient. The state has shown that there were factual disputes in this trial court's record at the time that the trial court granted summary judgment from consumers themselves, explaining that the disclaimers were hidden and buried and were not clear. In Removatron International Corp. Versus Federal Trade Commission, the court describes when a disclaimer is actually sufficient to change the overall net impression of the mailer. It states that disclaimers in a particular ad are not adequate to avoid liability unless they are sufficiently prominent and unambiguous to change the apparent meaning of the claims and to leave an accurate impression. Anything less is only likely to cause confusion by creating contradictory double meanings. Most of these consumers don't even recognize these disclaimers. The consumers who do recognize the disclaimers often will only do that once they're already on notice that they're not from the Secretary of State because they talked to the Secretary of State. Another consumer that mentions these disclaimers also describes them as ambiguous. He explains that he was confused about the contradiction of the threat of a fine from the statutory citation for not filing an annual report, when read in conjunction with the fact that this entity is not from a government entity. And that was the same consumer who stated he had to read the mailer line by line to recognize that the mailer was not about his annual report, but rather about keeping corporate meeting minutes. He was also one of the consumers who described the disclaimer as buried in the text or buried in the mailer. The state has sufficiently raised the question that should have gone to a jury by presenting these consumer declarations, by presenting the hundreds of consumers who were complaining. That was the evidence that the trial court had at the time that it granted summary judgment. And that ruling was inappropriate because summary judgment...
You just used the finite word, the hundreds of consumers that complained. I heard you say that there were declarations from the Secretary of State and declarations from another office, but did they suggest that there were hundreds?
Yes, they actually described the number of consumers who were, or complaints that they received. The Secretary of State did not have the ability to state every consumer that contacted their office with an inquiry, because I don't believe they were tracking that information, but they did state that they had to release notices, essentially because they had received so many complaints about both businesses, to put businesses on notice that these mailers were not from their office. So they got sufficient inquiries and complaints for them to feel that they actually had to do that scam alert notice. Summary judgment was inappropriate when the trial court granted summary judgment because the evidence produced at the summary judgment stage was such that a reasonable jury could return a verdict for the non-moving party. That was all that was required under Y Women's Center of Memphis, or Y versus Women's Center Care of Memphis. And the trial court got it wrong, unfortunately, in granting summary judgment. And thus the state asked that this court overturn the trial court decision granting summary judgment to defendants.
All right, thank you, General. We'll hear from the appellee. Good morning.
Good morning, Your Honors.
And will you be providing the argument alone, or
Your Honor,
are you dividing?
may it please the court. My name is Mark McGowan. I am appearing on behalf of what we call the LLPS defendants. I am here pro hoc vice, and I realize that is not a right. That is a privilege, and I am honored to be here.
We're glad you're here. But the question is, are you the only one going to be arguing for the appellates?
No, Your Honor.
Okay.
I would ask for half of the time allotted. I am just arguing on behalf of one of the
Very
appellants.
good. All right.
Appellate,
We'll
please.
program the clock for 10 minutes. Thank you.
May it please the court. My clients are Joseph, Thomas, and Justin Feda, and the LLPS company. I will refer to them occasionally as the LLPS defendants. It's understood that Joe, Justin, and Thomas and LLPS are separate and distinct from the ANS defendants. That is not disputed. The ANS defendants offer a completely different product than my clients do. The state must prove that my client's sales material is likely to deceive, not confuse, deceive reasonable Tennessee business people into thinking it was sent to them by a government agency, or that they are required by law to purchase my client's product. A failure to prove at least one of these elements is fatal to all three counts that have been brought against my clients. My clients offer a product that helps companies comply with Tennessee law. A shareholders' unanimous consent resolution, which is what my client provides, enables a corporation to avoid holding an annual shareholders meeting, which must be held every year unless the consent resolution is used. They also offer a director's consent form providing for the appointment of officers without the need for calling a board meeting. These forms are not provided by any government entity, and they are not filed with a government entity. The state has steadfastly claimed that these consent resolutions are a useless sham. The state is mistaken. The lower court has so ruled. The state has simply refused to acknowledge their own state's corporate laws. Actual physical copies of the sales material are part of the appellate court's record. Copies of those are attached as document number 8003. There's 9 different sets. They're in lime green colors. I left 8 of them over on the table here to my left.
Well, even if these documents are really nice things for people to use, couldn't the mailers, what she focused on was that the mailers made people think it was from the government and that they had to do this, order these things in order to comply with the law. So what about your mailers?
Yes, Your Honor. This is what the mailer looks like. This is what the Tennessee business person first sees.
Is that in the record?
Yes, Your Honor.
Okay.
And this is the same for each of the years at issue. Copies are provided to this court. And you'll note, first of all, that this is green. It's a unique color. It's not used by any government agencies in Tennessee, nor by the federal government.
Well, a consumer's not going to know that, are they?
Well, they'll know that they've never seen it before.
Well, I see things I've never seen before every day.
It doesn't mean a government
Well, Your Honor,
can't change its mind and use green the next year.
in the left-hand corner is my client's assumed name, Tennessee Council for Corporations, and just below it, it states, in large and darker letters, this is not a government document. And then below that, it says, this is a solicitation. So, at this point, before the envelope is even opened, The business person knows the key facts that are fatal to the state's case.
Well,
This is
instead
a-
of saying this is not a government document, wouldn't it be more accurate to say this is not a government agency? Immediately under your client's assumed name?
We'll come back to that in a moment, Your Honor. Fair enough.
I'd like to hear that now.
All right, Your Honor. When they open the envelope, the first thing they will see is the application form printed on one side, 14 by 8.5. And at the top of that statement, it again says that it's a solicitation. There's no emblems or state symbols here whatsoever. And near the top it says, Tennessee Corporations is a private company. It goes on to state that the corporate consent records may also be prepared by your corporate officers or other agents. The Tennessee Corporation Council is not a government agency and does not have or contract with any government agency to provide this service. This does not fulfill the Tennessee annual corporate filing requirements. This print here is larger than the other print surrounding it, and it's all capital letters. And then on the signature line it says, I certify I have read this document, understand its contents, and authorize the charges. The second document, again printed on one side only, no small print, is the instruction form. It again indicates that it's a solicitation. And at the bottom it states, you can engage an attorney to prepare this document. You can prepare them yourself, you can use some other service company, or you can use our service. It goes on to say this does not satisfy the requirement to file the annual reports set forth under Tennessee law. How did the Tennessee business people respond over the 13 years that these were sent? Well, the state claims there was thousands in their pleadings of complaints. But we analyzed all these so-called complaints, and we found that there were 2 Tennessee businesses from 2013 to present that purchased this product and claimed to have been deceived. Our affidavit to that effect is found at docket number 138. It was adopted by Judge Gaden in his findings of fact supporting the dismissal of this case. It has not been disputed. And what is it that explains this pristine record? That over 7 years, 2 Tennessee businesses claimed that they were deceived into purchasing. Well, I think, Your Honor, the answer is found in looking at the documents. The disclaimers, if that's what they're to be called, are perfectly clear. And I think it's fair to ask this question. How could a reasonable tennis business person be so naive as to believe that this document comes from the state or a state agency and believe that they're forced to buy this product? And I think the answer is found, Your Honor, by simply looking at these products. It just hasn't happened. Judge Gaden determined that Tennessee business persons are not that foolish. He determined that a reasonable Tennessee businessman would not find the LPS materials deceitful. But he was not the first person to reach this decision. In September of 2013, the president of LLPS traveled from Michigan with Michigan Legal Counsel and personally met with Jeffrey Hill, who is now the deputy of the Tennessee Consumer Protection Division. And with him was also Assistant Attorney General Jessica Myers. And they met and reviewed the green envelope, the sales order, the instructions, and the return envelope. And the Attorney General representatives made no objections. They effectively approved the sales material. And it is this same sales material approved in 2013 that has been used ever since by my clients. In Judge Gaydon's order dismissing the claims against the LLPS defendants, he noted the absence of any counter affidavit from the Attorney General's office denying that the 2013 meeting occurred or denying the significance that we have portrayed of that meeting. Additionally, prior to filing his complaint, the state hired Anthony Pratt-Canis, a well-known expert used in support of consumer deceit claims. At the state's unsuccessful motion for temporary injunction, Judge Gaydon said, "Where's your expert?" And they had none. And he commented and said, "You have a lack of evidence." 6 months later, in our motion for summary disposition, again, no expert report. And the judge indicated that there's a strong inference that the lack of an expert opinion would clearly would infer unfavorably on the state's case. In summary, it is submitted that the absence of the state's expert's report, the lack of a counter affidavit refuting the 2013 meeting and its significance, the clear, repetitive, and truthful language in the sales material, and a pristine 7-year marketing history reflected by the state's investigation all justify Judge Gaydon's summary determination that no reasonable jury could find that my client's sales material did deceive, does deceive, or is likely to deceive.
So, can't the AG change his mind? I mean, yeah, maybe there was a 2013 meeting. Yeah, maybe they looked at it and said, well, we think this is okay, but 7 years later, or whatever time, people change their minds all the time. Lawyers change their minds all the time. And I fail to see how that meeting is determinative of anything.
Judge didn't say it was determinative. He simply said that it was a presumption. There's so much other evidence, though, supporting that there was no dispute, and a complete lack of evidence showing that there was deceit. We have a 7-year record. The state did a 7-year investigation, and over that time, they came up with only 2 purchasers who claimed to have been deceived. And in addition to that, they hired an expert before this case was even filed. And the judge admonished them in March of 2021, where is your expert? There was no survey. There's no empirical evidence of deception.
I get that. I was just asking about the meeting.
I beg your pardon?
I was just asking about the meeting. I understand the other stuff.
Of course, Your Honor. I don't rest my case just on that meeting. But the compilation of evidence that we have supported as the party that is not burdened with we do not have the burden of proof. We have presented and shown a lack of evidence and provided our own evidence, and now it's up to the party with the burden of proof to step forward, and they haven't been able to do it. They've simply given their opinion of what this material is, but they haven't provided empirical evidence.
All right. Thank you, Mr. McGowan.
Thank you, Your Honor.
We'll now hear from the attorney for the second appellate. Good morning.
Good morning, Your Honor. Your Honors.
And we'll set the clock for 10 minutes as well.
May it please the court, Josh Bergner of the Nashville Bar on behalf of A&S Incorporated, Stephen Feda, and Teresa Feda. Your Honor, Your Honors, this case against A&S, the A&S defendants, is solely about the mailers that A&S sent to Tennessee businesses in 2018. With that in mind, I will specifically refer the court to the technical record where the notice appears. It's a large record, but it's in Volume 1, page 125 through 131, as well as Volume 51, pages 6900 through 6905. For the court's convenience, I have also brought with me samples if the court would like me to pass up copies. The trial court reviewed these mailers thoroughly, and relying on the net impression test as articulated by the Sixth Circuit in FTC versus EMA Nationwide Incorporated, a case that the state cites favorably, Judge Gaden found that the A&S defendants were entitled to summary judgment. In that decision, the Sixth Circuit wrote, the important criterion in determining the meaning of an advertisement is the net impression that is likely to make on the general populace. On summary judgment, the trial court must determine whether the evidence presented a sufficient disagreement to require submission to a jury, or whether it is so one-sided that one party must prevail as a matter of law.
In that same regard, we look to the likely effect the promoter's handiwork will have on the mind of the ordinary consumer. That's part of the same test in that case.
That is correct, Your Honor. And again, we would submit that if you review the mailer in question, that an ordinary consumer, a reasonable consumer acting reasonably, should not or could not have been confused. The one question of fact...
Wouldn't that be a jury question or a question of fact?
Not if it is overwhelming. And that is the case here. One of the points that was made early on in the presentation, I think actually by the state, is the volume of consumers or more rather the lack of. In this case, there were 7 declarations that were presented against the A&S defendants out of a total of more than 48,000 mailers that were sent out. These individuals, the vast majority, were not confused at all. And if the document was as confusing as the state alleges, then there would have, A, been more complaints, or B, more sales made in the state of Tennessee. The one question of fact is whether the mailer A&S sent to Tennessee businesses is deceptive. And in this instance, Judge Gaden found that there could be no such disagreement, that as in McBee versus CSX Transportation, the facts are, quote, so one-sided that the A&S defendants must prevail as a matter of law. Consistent with this court's decision in Tucker versus Sierra, the trial court evaluated the mailer in question and determined that it was neither unfair nor deceptive under the Tennessee Consumer Protection Act. In Tucker, this court held that a deceptive act or practice is one that causes or tends to cause a consumer to believe what is false or tends to mislead a consumer as to a matter of fact. Now, the state acknowledges in its briefing that deception can be determined at summary judgment, although conveniently the state claims, in the cases they cite, only allow summary judgment to be granted when it is a government agency making that request. But taking a step back, I think all this begs the question, what about A&S's mailer is actually deceptive? Again, I'm sure the court will thoroughly review the mailer in question, as Judge Gaden did, in doing so. But these are the facts, and they are undisputed. The solicitation envelope and mailers that A&S sent contain multiple explicit and conspicuous disclosures that A&S was not a government agency. There is a disclaimer on the envelope that says, not a government document. And then, in 3 separate places in the mailer itself, including right above the signature where one signs to verify the information, that says Workplace Compliance Services, which was the DBA that A&S was operating under, is a private entity and not affiliated with any government agency. Nowhere in these mailers is there any state indicia whatsoever. There's no seal, there's no website, there's nothing. Now, the state contends that the net impression test requires that, quote, the medium at issue be considered in its entirety. But what about the entirety of the document is confusing? It merely looks like a solicitation. A&S provided a service to Tennessee businesses by assisting them with the filing of their statutorily required annual reports, often at prices significantly cheaper than those charged by attorneys. So how can informing business owners of such an obligation, while specifically disclaiming that they are not a government agency, be considered deceptive? Now, the state contends that the A&S mailer makes a, quote, implied claim. But it's not clear what the implied claim is other than businesses in Tennessee have a requirement to meet certain statutory requirements, including filing of the annual report, a service that ANS assists with. Notably, in denying the state's initial request for a preliminary injunction, Judge Gaden specifically found that citing to a applicable statute, which is what happens in the mailer and on the envelope, is not deceptive under Tennessee law. ANS identified Tennessee businesses to solicit by purchasing a database directly from the Secretary of State's office for $1,000. This database was sold in a format that allowed purchasers to directly insert data supplied by the Secretary of State's office into another document, such as a commercial solicitation. The data that was sold included companies' addresses, dates of formation, registered agents, and Secretary of State's control numbers. The state makes a big deal, as do some of the declarants, that that information was what was confusing. But if that information was confusing Tennessee consumers, why does the Secretary of State's office continue to sell the database that includes that information for solicitors to use?
It's a public document. A public document.
But it is able to be purchased.
Yeah.
So
You don't get them for free.
respectfully, Your Honor, if the state believes certain information is confusing or could create a confusion, it should not be selling them in that format. It is a public document. You would be able to look up every Tennessee business's Secretary of State control number or other information, but that's a lot more complicated and probably wouldn't be done as compared to the way the state sells the information.
I know your other counsel suggested that the complaints received when actually analyzed were minuscule on this issue. But did I understand correctly that the Secretary of State got so many calls about this, they put out notices explaining that these solicitations weren't from them? And doesn't that indicate a fairly significant level of confusion?
The Secretary of State's office did put out a mailer. In discovery, we requested information as to the number of complaints and how they were kept, and were not provided that information.
Well, I believe she said the Secretary of State didn't keep up with that.
That may be the case, but it's then difficult for us to respond to or knowing exactly what the volume is if the Secretary of State says, oh, we were getting a lot of complaints, but we can't tell you how many, and then are relying on a very small number of declarations to make that claim. Now, in the mailer itself, the state contends that the disclaimers are, quote, hidden and dense and in a compact text form. Again, that's not really the case if you look at the mailer itself. Additionally, the state argues that the ANS invoice was deceptive because it looks like an invoice. And again, I would invite the court to look at the mailer in question. It looks nothing like an invoice. In fact, one of the cases the state cites, FTC versus cyberspace.com, it's distinguishable from this case because that case involved deception because of very fine print where there were the disclaimers were placed. But in that case, in addition, the court found that the document in question was confusing and appeared to be an invoice because it contained an invoice number, an account number, and a discount taken, which implied a pre-existing relationship. That's not the case in this mailer at all. Simply stated, the 2018 mailer looks nothing like an invoice. And in conclusion, Your Honor, again, we would contend that the trial court found under the net impression test, a reasonably prudent consumer could not perceive the mailer sent by ANS to be a government document. The trial court found that the mailers contained prominent and unambiguous qualifications and disclaimers that accurately advise and confirm that the mailers were neither from nor associated with a governmental entity. With that in mind, we ask the court to affirm the lower court decision and maintain summary judgment. Thank you.
All right, thank you, sir. We'll now hear rebuttal from the state. General?
In your I'm going to go ahead and ask. In your first appearance up here, you read a very interesting definition of consumer from a case. And, you know, the judge below and counsel here refer to reasonable, prudent consumer. And that seemed very different from what you read as a definition of consumer. So my question is, what definition of consumer do we use here?
Thank you for asking that question, Your Honor. That was actually going to be one of my points, is that the judge did actually impose a higher burden than a consumer acting reasonably under the circumstance. You won't see a reasonably prudent Tennessee consumer in any case law or any deceptive advertising case law for that matter. It imposes what Black's Law Dictionary described when they described prudence, this idea that you have to be sensible and careful, especially in trying to avoid unnecessary risk, which is not the burden for consumers under the Tennessee Consumer Protection Act or deceptive advertising law. It's not a heightened standard. It's instead a standard of the ordinary consumer acting reasonably under the circumstances. And that's the exact standard that you will see in case law and supported by case law.
And that was defined in the case that you quoted from?
Yes, Your Honor,
Okay.
in several of the cases.
Thank you.
LLPS also spends considerable time talking about the difference between the two companies. And most likely because it wants, or defendants want you to siphon out the declarations and say, this number is for LLPS, this number is for ANS. However, this case isn't actually about the provision of services. This case is about their advertising scheme. And their advertising scheme is remarkably identical and unfortunately did mislead consumers. Defendants also stated that the state had to contradict evidence that the state had approved mailers. However, if you look at the declaration that was provided, there was actually, by David Brigg, there was actually nothing in that declaration that stated that this state approved its mailers. In fact, as all it stated was the state sent a request for information because it was investigating the mailers for their likely to mislead. But actually specifically stated for violation of the Tennessee Consumer Protection Act. And that was the basis for that meeting. There was no express approval in that situation. And so there was no evidence suggested at the trial court level that the state had initially found that these mailers didn't have a tendency to mislead consumers. The defendants have also raised a quote from EMA, or FTC versus EMA. And they're correct that the court, Sixth Circuit, found that in some limited situations, summary judgment may be appropriate. In EMA, the court was looking at express misrepresentations. And that's why it was able to find on the face of the document on summary judgment that the representations were misleading. They were false on their face. That is not the facts of this case. Further, in EMA versus FTC, the procedural history was actually very distinct, and that defendants didn't oppose FTC's motion for summary judgment. So the evidence that they presented, which was also consumer declarations, was uncontroverted in that record. Unfortunately, the EMA defendants' documents had been seized, so they had no way to dispute the FTC's evidence. In this case, however, the state has presented evidence from consumers. Defendants wanted the trial court essentially to substitute its judgment and its ability to see whether or not a disclaimer is prominent for what consumers have already described to be misleading.
Do you have to have an expert if you've got consumers who say they were misled? And what do you need the expert for?
Your Honor, You are correct. There is no need for an expert. In FTC versus cyberspace, there was no expert testimony presented. And in the case that all parties are citing, FTC versus EMA, there was no expert opinion. Instead, the court relied on what consumers described are misleading, what consumers said their understanding of the mailer was. And consumers stated that although when they finally did notice the disclaimers, they weren't sufficiently prominent and unambiguous to change the overall net impression of the mailer, and misled them to think that the mailers were from the Secretary of State's office or a company affiliated with the Secretary of State's office. This court only has to find that the state has presented sufficient material factual disputes in the record, and it has. And thus we ask that this court overturn the trial court decision granting summary judgment to defendants.
You're simply asking, am I correct, by stating that this, what you stated, that this is an issue for factual determination and not an issue that says upon its face that based upon the law that this case should not proceed. You're just asking for factual determination,
Yes,
either
Your
by
Honor.
a jury or by a judge, as to this issue of being misled.
Yes, Your Honor. The judge should have allowed this to go to a jury and a jury to decide whether or not it would mislead consumers. And the judge had material factual disputes at the time that it found that there was none, and that's why it erred.
Okay.
All right, thank you. Thank all three of you for your arguments. We will take this matter under advisement.